Hello friends, I am Chittaranjan Kanungo, Deputy Director Prosecution Odisha. As usual, in our academic interest, let us discuss about the different features of investigation in respect of 498A IPC. 498A IPC is a penal provision provided under the statute for punishment of husband and relatives of a woman, those who commit cruelty against the woman. And cruelty has also been explained in the provision itself. The explanation provided under the provision is that cruelty means any willful conduct which is of such nature that it is likely to drive the woman to commit suicide or to cause any grave injury to her body or limbs. That apart, cruelty is also a kind of harassment by husband and relatives to the woman, where such harassment is with a view to coerce her or any person related to her to meet any unlawful demand of any property. So, cruelty encompasses both physical cruelty as well as mental cruelty. And physical cruelty in general means actually beating the woman, causing any physical assault, any push, pull, dragging, etc. But so far as mental cruelty is concerned, it is of different variations. It can be also emotional one, humiliating, ridiculing, threatening, not providing the basic amenities, not providing food, medicine, cloth, etc. These are the types of cruelty which are very emotional and mental in nature. So both the kinds of cruelties are punishable under the provision. So far as relatives, the concept is concerned, relatives means not anybody who can be termed as a relative. Earlier, even the neighbors and some distant relations, and sometimes it is also found that mediator of the marriage, they were being termed as relatives to the family of the woman, and they were being implicated as accused persons in a case basing upon the allegation of the woman. But the term has been well analyzed by the Supreme Court, and the latest view is that a relative means the persons who are related to the family of the husband of a woman, either by blood, by marriage, or by adoption. So these are the three ways of relationship to define the term relative. So demand of dowry or demand of delivery of any property or any valuable security is the very first and foremost requirement of section 498A IPC, and the property or the valuable security when demanded as a matter of dowry, then section 4 Dowry Prohibition Act is also applicable. Dowry can be demanded at any time, that is before solemnization of the marriage, during the course of marriage, or even after the marriage when the woman lives in the matrimonial house. During the course of investigation of a case registered on section 498A IPC coupled up with section 4 Dowry Prohibition Act, or even if 498A IPC independently, some common questions arise during the course of investigation. First question is, who can be the complainant? Section 198 CRPC is an enabling provision for prosecution of section 498A IPC, and in that provision it has been provided that no court shall take cognizance of any offence on section 498A IPC except upon a police report or upon a complaint made by the aggrieved person, her father, mother, brother, sister, or father's brother or sister, or mother's brother or sister. So when any case is registered at the police station on section 498A IPC and a police report is being submitted, this provision makes it permissible that court can take cognizance notwithstanding the fact that who is the complainant. But better if complainant is a person out of the categories provided under section 198A CRPC. The second question is, what is the time limit for registration of the case in such offence? Actually, there is no time limit. It is a recurring offence since it occurs in the matrimonial home of a woman. It is very recurring in nature, very repetitions are there. Day by day it happens. So there not being a very particular date of occurrence, it can be reported at any time whenever the woman feels aggrieved by action of her husband or by any overt act of the family members. Jurisdiction issue is also a matter of discussion in the cases registered under section 498A IPC, and it is well settled by the Honorable Supreme Court of India that different places related to the complainant are the jurisdictional areas, and in all concerned police stations the case can be registered. The case can be registered in the police station under the jurisdiction of which her father's place is situated. So also the case can be registered in the jurisdictional police station under which the marriage was solemnized, in the jurisdictional police station under which the matrimonial home of the complainant is situated, and also in the jurisdictional police station under the jurisdiction of which the complainant or the victim is lastly residing. So there is no anomaly. It is the choice of the complainant in whichever police station she can register the case as per her convenience. Another vital question arises whether strict proof of marriage is essential in a case under section 498A IPC. Actually, strict proof of marriage is not required. Had it been so required, the word wife would have been there in the provision itself. In the provisions of section 498A IPC, the word wife is not there. The word woman is there. So it is the objective of the legislators not to insist upon strict proof of marriage. And what is required? It is required that they should have the relationship of a husband and wife, and they should be living in the society as husband and wife to the knowledge of the society at large. So if it is duly proved that both the persons, the woman and her husband, are living together and maintaining their conjugal life to the knowledge of the neighbors, to the knowledge of the larger society, then strict proof of marriage is not required. Another issue, it is also very important, that is whether after registration of a case under section 498A IPC, another case subsequently can be registered by the victim, and whether it is hit under the principles of double jeopardy. After due analysis, it is found that section 498A, the provision itself, provides for punishment against husband and relatives of a woman whenever they subject the woman to physical or mental harassment, torture and cruelty. Once the case is registered by the written report of the complainant, is not ipso facto a bar for registration of a subsequent case if such offence is committed repeatedly after registration of the first case. So the principle of double jeopardy is not applicable here, because after registration of the first case, if the second case comes to notice of a police officer by means of a written report of the complainant, and if at all it happens or the complainant is subjected to torture or cruelty after a couple of days of registration of the first case, then the principle of double jeopardy will not be a bar for registration of a subsequent case. It can be registered. In many cases, it is found that the first wife is living, another woman is accepted as wife by the husband, and such woman who is treated as the second wife of the accused husband, she files a written report in the police station that she is being subjected to torture and cruelty as provided on section 498 IPC. Now a sole question arises whether that case should be registered as one under section 498A IPC, since the status of the woman as wife of the accused husband is not so clear, because a first wife is living who is recognized as the first wife of the accused, and this is the second woman who is living as wife of the accused husband. Whether her case should be considered whenever she alleges that she is subjected to offense under section 498A IPC. The answer is yes, because she is also living with the accused as his wife. First wife, second wife, and what is her status, that is immaterial. That is why the term woman is there in section 498A IPC and it is not written as wife. So considering that provision, it is very natural to consider that even the woman is living with the husband as his second wife or maybe as his concubine, still then, if aggrieved, she can lodge an FIR or she can file a complaint against the husband and relatives for commission of offense on section 498A IPC. Arrest of the accused persons who are alleged to have committed offense on section 498A IPC is within the power of a police officer, as the offense is cognizable as well as non-bailable in nature. But in the case of Ornesh Kumar versus the state of Bihar, Honorable Supreme Court held that there is rampant misuse of the provision of section 498A IPC for oblique purposes with a motive to harass the husband and in-laws. Some cases are also filed by the complainants. In that particular case, Supreme Court provided a set of guidelines in the matter of arrest of the accused persons. And it is also held that in the offense under section 498A IPC as well as in the offenses in which punishment is less than 7 years of imprisonment, a notice will be sent to the accused persons. And if the accused persons oblige that notice of the police officer and cooperate in the process of investigation, then the accused persons may not be arrested. Accordingly, a provision has been incorporated in CRPC. In section 41A CRPC, it has been provided that if the offense committed carries punishment of less than 7 years of imprisonment and the police officer is satisfied that the arrest of accused is not required, then without arresting the accused, the police officer will serve a notice upon the accused persons, and if the accused persons comply with the terms of the notice and cooperate with the investigation, then they may not be arrested. And without arresting the accused persons, charge sheet can be submitted. So these are some basic issues in investigation of a case under section 498A IPC. In future, we will have more fruitful and productive discussions on investigation of different offences. Thank you.